Hello, guys. This is Dr. Hart. I am chiming in this week. I also, first of all, before I get started on course material, I hope that each and every one of you is safe, secure. I know we had a rough week last week with the weather. I hope that you all and your families are doing better now. If you need anything as far as what we missed on last week, let me know. Also, I don't know if you make sure you're reading the announcements, but I did make an announcement that Learning Module 1 material, meaning the assignments, all of it has been actually extended through next Monday, 11:59 p.m. So basically, I'm giving a 1 week extension for the Learning Module 1 assignments that were due on Monday. So if you have any questions, please feel free to contact me. So what I want to do quickly and just briefly just kind of mention some areas that were covered in Learning Module 1, mainly ethics, okay? I want to talk about ethics. Ethics is very, very important in the realm of being a legal professional. I know some of you have probably heard the lawyer jokes and all of the jokes about bad lawyers and lawyers are this, lawyers are that. Of course you have bad apples in every profession. But on the whole, we as legal professionals, we're pretty ethical people because we're bound to be so. We're bound to be so legally. And as attorneys, we are licensed and we must make sure that we are abiding by the ethical rules and practices. If not, we can, lose our licenses. Now, paralegals are not licensed. However, paralegals, you guys are also subject to ethical standards. Anything that an attorney is unable to do, that extends to a paralegal as well. I just, want to mention some things such as candor, confidentiality, conflicts of interest. Those are areas that are kind of hot buttons when it comes to the area of legal practice. For instance, as a paralegal, you are bound to maintain confidentiality when it comes to clients, their issues and their information, because there is what we call an attorney-client privilege. So anything that a client discloses to that attorney is confidential and it's privileged. And that privilege and confidentiality standard extends to paralegals as well. So, if you're working in an office and you come across some information regarding a client, it is unethical for you to disclose that information, okay? There are some instances where you may be required to, but of course, if you ever have issues relating to, should I not, always consult your attorney on that. Also, a big one, probably the one that's most applicable to paralegals, is what we call the unauthorized practice of law. It not only is practicing law without a license unethical, it's also illegal, okay? And here's a link to a website that is in your Learning Module 1 that talks about the unauthorized practice of law. And I think you can see here on my screen that the unauthorized practice of law is illegal in Texas. It is a violation of our Texas Penal Code. So with that said, as a paralegal, I know on one of the assignments you guys had to discuss some of the duties and tasks that paralegals perform. There are many: drafting, the initial client interviews, gathering information, performing research. All of those are tasks that paralegals can perform. The exception to that is practicing law, all right? Practicing law entails doing things like signing the pleadings as the attorney. You never want to hold yourself out as an attorney until those of you who aspire to do so go on to law school, pass the bar, and get your law license, okay? That's the only time when you'll be able to hold yourself out as such. And I know that some of you have already completed the initial client interviews, and some of you are still working on those through the extension. What I want you to also note if you are actually interacting with clients, sometimes lay people can't tell because a lot of paralegals, you guys are you're educated and you're schooled in law, so you will know quite a bit, maybe just as much as some of the newer attorneys, so to say. But you want to make sure that the client and the public knows that you are the paralegal, you're not the lawyer, and if there's something that they need a definitive answer to relating to their case that involves something to that sense, you would have to consult with that attorney first. Never give that legal advice. And even now, and I've told my students this before, sometimes you'll have family members who are like, oh, wow, you're studying law, you're in paralegal school. Hey, I have this question. Can you answer that? No. Even then, that is practicing law without a license. Don't get caught up in that. Please don't, because not only is it unethical, but it is illegal. Okay. Something else here, like I said, your client interview questions. I saw some really good questions so far. Also, but something I'm noticing, make sure when you're initially interviewing a client, real world situation, make sure you're gathering their contact information. The goal is to not have to constantly call that client back. Hey, Mr. Jones, I'm sorry, I forgot to get this information. I forgot to get your driver's license number, blah, blah, blah. You don't want to continue, going back and forth because it may appear as if we're not competent at that point. Also, in your initial client interviews, a lot of attorneys will have what we call a medical release form. Because, especially if you're dealing in civil law and your client is claiming some type of injury and their medical reports on records that we'll have to get, the client will have to sign an authorization to allow us to get that information from their healthcare providers. That's something else that we recommend that you get up front during that initial client interview. So those are just some tidbits on initial client interviews. Also, to round out learning module 1, we talked about evidence, okay, preliminary. These are preliminary considerations. Ethics, also during your investigation, you have to be able to differentiate between direct and circumstantial evidence, all right? Direct evidence is what it implies, direct, okay, like eyewitness testimony, okay. Direct evidence, maybe fingerprints or something like that. But circumstantial is basically the type of evidence that it's inferred or presumed, okay. For instance, in your Cook case, if it could be presumed, it could be circumstantial evidence that the defendant was exceeding the speed limit, even if we don't have any direct evidence of such. So make sure you differentiate between direct and circumstantial evidence. I have a link here on hearsay evidence. Evidence is, when it comes to determining the admissibility of evidence, meaning whether or not evidence can actually be submitted for a jury's consideration, that is a practitioner's consideration. That's basically in the attorney's purview. The attorney makes that initial determination because there are rules of evidence that we must follow, okay? Not all evidence is the same, not all evidence is relevant, and not all evidence is admissible. What I want you to do take from this is to know exactly, just kind of an overview, direct versus circumstantial evidence, what the differences are. Hearsay evidence. Hearsay, I remember in law school, it took us forever to kind of like, what the heck? It's very vague. And I don't want you to get overwhelmed by that. Just make sure you understand, generally, hearsay evidence is not admissible. It's basically considered, it's kind of akin to secondhand information, okay? However, there are some exceptions to the hearsay evidence. I'm not going to dwell on the differences too much. I'm most likely not going to even test you over that. But when you hear the term hearsay, the term or the phrase hearsay evidence, know generally it's not admissible, meaning that it generally does not come into the jury, come in during the trial for the jury's consideration. However, there are some exceptions to that. Also, make sure you know the differences between direct versus circumstantial evidence. Go through and it's just a matter of having a foundation and just have a working knowledge of what the differences are between those. And that's going to round out Learning Module 1. I have also opened up Learning Module 2. I don't know if you guys have had the opportunity, because we are a week behind, but we will be fine. We have plenty of time to finish up the semester. We're on course. We won't be behind on anything, but Learning Module 2, make sure you go into Learning Module 2 this week if you can and check out the overview. In Learning Module 2, we're going to draft initial civil pleadings, okay? We're going to learn about what we call the complaint, okay? Basically, we're going to take our Cook versus Washington case. For those of you who have not had the opportunity to read it, it is a case involving a car accident, which is a personal injury civil case. And what we're going to do, we're going to read the case. Make sure you read the facts of the case. We're going to draft a complaint, meaning we're going to file a lawsuit. Okay, you've already started to draft some of the initial client interviews. We've interviewed our client. We have his information that we need, and we're going to review the case, the facts of the case, and now it's time to draft the complaint. We're going to draft that complaint, and we are going to basically start our lawsuit against the defendant. Make sure you read about the complaint. Chapter 5, what the complaint is. It is basically the initiation of the civil lawsuit. We're filing a civil lawsuit against the defendant. Also, ProDoc, there is a link. No, rather it's a folder. It's a yellow folder that's on the homepage of your Blackboard course. If you can download ProDoc, it's a legal drafting software. The links are safe, and it is Texas specific, and we are going to use it to draft the complaint. Now, one thing you will notice with ProDoc, in Texas, we call the complaint a petition. Okay, it's the same document. It initiates the civil lawsuit, but it's called the petition. That's what we call it in Texas. So you'll be drafting your initial client petition your initial petition to start our civil lawsuit in the Cook versus Washington case. Make sure you go ahead this week, start downloading your ProDoc. However, a caveat, it does not work. It's not Mac compatible, but I have included a Word doc on the homepage for you guys to use. If you have a Mac, you'll have to just go ahead and use the Word document and modify it yourself to fit the petition, to fit what we need. But I will chime in again in maybe a few days or beginning of next week just to see how things are going. But go ahead, finish up Chapter 4 or Learning Module 1. Those assignments are extended through 11:59 p.m. next Monday, March 1st. Also, let's go ahead and get going into Chapter 2. At least review Chapter 5. Learning Module 2. Review Chapter 5, know what the complaint is. Review the facts of the Cook versus Washington case, and go ahead and download, if you're able to, the ProDoc software. We're going to use that to draft not only the initial pleadings, but also for some discovery motions later on. Anyway, if you have any questions, give me a call or shoot me an email. All right. Have a great rest of your week. I will talk to you guys soon. Bye-bye.